Can hidden surveillance video destroy your damages claim in a medical malpractice case? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. And the answer is absolutely yes, it can. Everything's on video today. Everything is hidden video. Everything is surveillance video. From body cams to Google cams to cameras on walls and cameras are hidden somewhere. Cameras are everywhere today, so all of your actions, you have to assume that they are being recorded somehow, somewhere. So now you decide to bring a lawsuit against your doctor claiming that he was careless and that his carelessness caused you significant harm and injury. And during the course of your lawsuit, you claim that your injuries are in fact permanent and significant. And as part of your damages, you are claiming that you are no longer able to do many of the daily activities that you used to be able to do. You're no longer able to run, you're no longer able to go bike riding, you can't go rock climbing, you can't go skiing, you can't play basketball, or you do certain activities only to a limited extent. During the course of your lawsuit, not only will the doctor and his attorneys turn around and say, hey, why did you sue us? We did nothing wrong here. They're going to turn around and say, you know what? If we did something wrong, guess what, Mr. Patient? So did you. That's called culpable conduct. And then they'll say, if we did something wrong, whatever we did didn't cause you significant harm and injury. That's causation. They're arguing that there is no link between what they did and your injury. And then, to top it off, to dig the knife even further, they turn around and say, you know what? Okay, maybe we did something wrong and maybe it caused you harm, but guess what? Your injuries really are not as bad as you claim them to be. So now your litigation goes forward. And during the course of litigation, unbeknownst to you, the defense turns around and makes a strategic decision to try and get you on video. Why would they do that? Because they're going to hire a private investigator with a video camera to try and capture you doing your daily activities, unbeknownst to you. They're going to get you on hidden video. They're going to follow you from the moment you leave your home to the time you get to work, to the time you do your daily activities and run errands, and now you come home. They want to capture you during your daily activities. And they are hoping that during the course of their video surveillance, whether it's over a course of a day, a 2, a week, or more, that they capture you doing something that you claim you can't do. So what they'll do is, they'll go ahead and get that private investigator to follow you, and you won't know that you're being followed. And then they will question you during the course of your litigation at a question and answer session known as a deposition. Now that's part of the litigation process. Since you are the one bringing the lawsuit, the people you have sued by their attorneys have an opportunity to question you, to learn what the problem is, to learn what you claim you can and cannot do, to learn what happened to you in your own words. This is known in legal circles as an examination before trial or a deposition. And it takes place in your lawyer's office, but you should know there's no judge present, but there is a court reporter present, and you swear to tell the truth. And here's something else you may not know. That sworn testimony, the answers that you give in response to those questions, carry the same exact weight as if you are answering those questions at trial. So even though you're in an attorney's office, there's no judge, there's no jury present, what you say carries the same exact weight as if you are testifying at trial. So now the defense attorney is going to be asking you questions like, Mrs. Jones, what activities are you unable to do today because of whatever the doctor did wrong? Oh, I can't play basketball, I can't go rock climbing, I can't go bicycling, I can't ice skate. Okay, and you give this whole list of things. All right, and are there certain activities that you are limited from doing that you can still try and do but do it with difficulty? Yes, I can't go swimming, I can't do this activity, I can't walk up and down stairs well without pain. Now why do they do that? Because they want to know from you what it is that you are swearing to tell the truth about concerning your injuries. They want to know what problems you have today and what things you can no longer do that you used to be able to do. And they will likely already have surveillance video of you at the time you give this testimony. And they will compare what they captured on video with what you talked about in your deposition. And then in all likelihood, weeks or even months later, they will get a private investigator to come back and do additional surveillance on you. Why? Because they want to see whether or not your activities have changed. They want to see whether or not your activity level is different. And more importantly, they want to see, is there a smoking gun that totally destroys your credibility? So they may capture you doing an activity that you claimed you couldn't do. Maybe you're out playing basketball with some friends, and now they got you on video playing basketball. Maybe it's the middle of the summer, you went swimming. But what's interesting is that these videos are not the be-all and end-all, even if they capture you doing an activity you claimed you couldn't do. Very interesting. Because not only is it important to recognize what's on the video, but it's just as important to understand what's not on the video. Now, what do I mean? I mean that video can't capture everything. So now you've talked about in your deposition, you've sworn to tell the truth that you cannot do certain activities, or you can only do them in a limited fashion and that you have pain doing those things. All right, fine. But one of the things that video can't capture is pain. What pain are you feeling or experiencing? What medication have you taken because of that pain? What are you able to do now? What is your mindset? Are you willing to try those activities to get past the pain? Yes or no? You might be willing to try it just to see if you can do it. That may be the time that they captured you doing it. And now what does that mean for you? It doesn't mean your case is over, but it now means you're going to have to do some explaining at the time of trial. So your attorney gets a package from the defense that says, hey, here's a package for you. Time to get your popcorn. Go pop this into your computer. And now your attorney goes ahead and watches the video to see what's on it. If in fact the defense caught you on video doing something that you claimed you could not do, now you got some explaining to do. Now you got a problem. You've got a credibility problem. And that one little untruth, that one little lie may destroy your entire case. You want to know why? Because at the very end of the trial, after all the testimony has been put on, after all of our witnesses testified, after all the evidence goes in, and after the defense puts on all of their opposing experts, the judge is going to instruct the jury on the law about this one little thing. It's called falsus in uno. And that's a fancy Latin phrase that means if a witness has testified falsely about one thing, you have the right, jury, to go ahead and disregard all of their testimony. You don't have to, but you certainly can. So what that really means is that if you've lied or been less than truthful about your activity level, the defense is going to point all of his fingers during closing argument saying, what a liar you are, you're being untruthful, and how can we believe anything else this witness has said if he lied about one little thing? And that's a very powerful, compelling argument. So why do I share this great information with you? I share it with you because this does come up. And now you claim you can't do certain activities, and in all likelihood the defense will try and get surveillance video of you, and if they catch you doing something that you claimed you couldn't do, you may have a significant problem. You know, I do realize you're watching this video because you likely have questions or concerns about your own matter. Well, if you have not yet started a lawsuit and your matter did in fact happen here in New York, and you're thinking about bringing a case, but you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, @ Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.